Managers, team leaders, and frontline supervisors today face an incredible number of challenges. Reorganization problems, competition on an international basis, the incredible infusion of technology and the change that that brings. Coupled with these challenges is a network of complex employment and labor laws that govern conduct in the workplace. 1 out of 5 managers will become a participant in the litigation process. One of the great values of having looked through tens of thousands of cases is that you start building up an understanding of certain types of conduct, very specific conduct, that comes up time and time again and represents a real problem in the litigation arena. Something that if we could only get the word back to the manager in the beginning, that this is a problem, the behavior could so easily be changed and turned positive and not appear as a landmine later on in litigation.
I just found it difficult to find a way to talk to him. It was very frustrating.
He sounds like the employee from hell. Was he your hire?
Oh, no. I inherited Paul when I got the promotion. You know, I couldn't figure out if he had been with a company for too long or if he just was having a problem working for a woman. But definitely, he started to act as if the rules just didn't apply to him anymore. You know, when he came in late the 5th time one month, I knew that I had to deal with it. Good morning, Paul.
Morning.
May I see you in my office for a second?
Sure.
The analogy of a landmine is highly appropriate. There are events and circumstances that are out in the workplace. There's conduct that takes place. And if you're unaware of it, if you simply are looking in the other direction and carrying out your duties and trying to accomplish the business tasks of the organization, it is so easy to step on the landmine and later hear the explosion.
This is the 5th time this month that you've been late for work.
That's impossible.
No, it's not. I've been here, and I see what time you come in.
Hey, no offense, but I've been here 15 years. 15 years and nobody else has ever had a problem with how I do my work. Nobody.
That's great, Paul. But I need you to be here when you're supposed to be here. No exceptions. Unless you make some prior arrangements directly with me.
Fine. Is that it?
Yeah, that's it. I mean, clearly he didn't respect company policy, and he certainly didn't respect my ability to enforce it. So I decided to fill out an incident report.
Hey, Julie, can you pick up?
Hi, Bob. The Anderson report? Oh, right. Okay, you need it right now.
Now, Ms. McMillan, you say that you spoke to Mr. Hayes on numerous occasions about your dissatisfaction with his performance. Is that right?
That is correct.
And did you ever make a written notice of Mr. Hayes' performance deficiencies in his file?
Well, you have to understand, it was very busy at the company at the time. We had gone through a reorganization, and there were lots of projects going on.
Well, Ms. McMillan, we're all very busy, but evidently these matters weren't so serious that you felt the need to record them in Mr. Hayes' personnel file. Isn't that correct?
Well,
Well, yes or no, Ms. McMillan?
no.
Out of the cases that come through my desk, 90% would go away if there was a clear record of what occurred.
If it is not written down, it didn't happen. And you have to assume by the time you come to trial that there will be two vastly different stories about what occurred.
It doesn't mean that every single statement and every single detail has to be written down, taking up unreasonable amounts of time for a supervisor or manager. It can be as simple as a one-paragraph statement about a meeting that was held with an employee, about what was communicated to the employee.
And the benefit of that kind of documentation is that the manager is also sending a message to the employee with regard to what the expectations are, and often you will see the performance dramatically improve.
Where is everybody?
The software training?
Oh, right.
No, the mandatory division-wide software training.
Look, I don't know what I could have done. I've had this appointment for a month.
Look, Paul, this is important to the whole team. You'll have to schedule a makeup date next week, okay?
If I do that, Caldwell's deadline is history. Why do we always have to have these new software things anyway?
Because if we learn how to use these new software things, they work. That's why it's mandatory.
Julie, you're right. Why don't I take the manual home and learn it myself instead of blowing half a day in a seminar?
Okay. Just make sure you learn it. It's important.
One of the primary responsibilities of being a manager is the responsibility to counsel and to train your employees.
And increasingly, we find that both courts and the juries are placing a responsibility on the employer, on the organization, to ensure that the necessary tools, the necessary training was put in place to allow the employee to succeed.
All right, Mr. Hayes, let's turn for a moment to the subject of your training, the morning of November 10. Can you tell me what happened that day?
Well, I had a doctor's appointment, so I arrived at the office around 10:30.
And what happened when you arrived at work?
Ms. McMillan informed me that I had missed a mandatory training session on the new software system.
Did Ms. McMillan make any arrangements for you to make up this mandatory training session?
She did not, but I volunteered to take the material home and learn it on my own.
And did Ms. McMillan follow up to determine whether or not you had received the training on the software?
It was never mentioned again.
The obvious approach that an employee can take is that the supervisor knew that if they did not have that training, that they would fail. And so therefore they failed because the supervisor made them fail.
Documenting opportunities for training, documenting the need to train, following up and ensuring that the training has occurred are the best ways of guaranteeing that the employee will in fact get the necessary skills, and you never enter into the litigation process because you've got an employee that's meeting your expectations and standards.
It still amazes me that Paul really thought he was the most productive member of the whole team. You know, I remember once. We need to reprioritize some of the deadlines in the project. The first one is yours, Ron. I'm gonna need to get these revisions back by next Friday. Can you handle it?
Probably, provided that I can get some help.
Okay, Carmel?
I'd have to put the recoding on hold.
No, you stick with that project. I'll just give it to Paul.
Where is Paul, anyway?
He called in sick.
Again?
Well, so everybody knew he wasn't keeping up.
It just got more and more ridiculous. We had to cover for what he couldn't do and fix everything that he did do. I mean, I had given him a report back twice to fix his typos, and when he gave me back his final draft, the first page had 4 mistakes. Well, guess who stayed late that night?
A landmine that you can literally hear exploding is a piece of paper hitting the waste paper basket that's being thrown away out of rage because the manager is so disappointed with the quality of the workmanship.
Even worse, they give it back to the employee and say, see, this is an example of what you've done that I have found to be inadequate. And of course, then the document disappears. It's very important that if you do give it back to the employee to redo, that you keep the original and you give them back a copy.
That particular document is one of the best forms of documentation of the problem that they're discussing, and in fact could be used as a teaching tool with the employee to show them precisely what they did wrong, and later could be invaluable in the litigation process as solid, tangible evidence of what the performance problem is and why this manager is having problems with the individual.
I have to ask you, if Paul was such a problem, how did he stay with the company for so long?
Oh, Paul was savvy. He knew how to play the game. I mean, I'm much more straightforward with people. Paul always seemed to have a hidden agenda. You know, I remember this one night I was working really late and I went to leave and Paul was still at the office. Paul? What is this? The third time this week?
You said you wanted this stuff out by the 15th, so I just figured I'd get on it.
Well, what about your girls?
Oh, they're at Grandma's. Yeah.
That's okay.
They love it. Their schoolwork suffers a little bit, but not to worry.
I really appreciate it, Paul. I'll see you tomorrow.
Look, Julie, I know there are people here that think I don't pull my own weight, that, you know, I'm not a team player, but, well, I'm gonna prove them wrong.
Okay, Paul. I'll see you tomorrow.
You know, in retrospect, I realized that Paul's touching display of sacrifice and, well, dedication came right before his annual review. I ended up giving Paul an overall performance rating of a 3 on a scale of 5.
Uh-huh.
Well, the way I saw it, everyone else in my department was getting a 4 or better, so that still left Paul with a lot of room for improvement.
One of the landmines is where a supervisor, in a desire to be encouraging and positive, inflates the grade and the evaluation of the individual. And sometimes they do it out of a feeling that if they just give the person a positive evaluation, that person would do a better job, will try harder, will feel better about their job. But sometimes it has the opposite effect. And the opposite effect is that when it comes time to make a disciplinary decision, when it comes time for termination, the manager's own words are going to be used against him or her.
Ms. McMillan, I'd like to show you a document. Have you ever seen this document before?
Yes, it's an employee evaluation form for Paul Hayes.
And is this an evaluation which you filled out?
Yes, I did.
And would you please read to the jury your entry under the heading Work Performance?
Employee's performance has been satisfactory and is consistent with the specifications.
Excuse me, could you speak a little louder, Ms. McMillan?
Employee's performance has been satisfactory and is consistent with
The
the
manager
specifications of his job
perceives that since he gave the employee an average rating, that he met company standards but didn't go above it, was really telling the employee that he was doing relatively poorly in the organization because in the manager's mind, everybody else got higher evaluations. The employee, on the other hand, is hearing that they met the company standards and expectations, and they are either not hearing at all that happens to be the lowest grade in the department, they aren't told that information, or even if they're told that information, they still feel relatively unthreatened because they feel they're at least meeting the standards or expectations of the company.
Now, I'd like to direct your attention to the bottom portion of the evaluation. Would you read that to the jury, please?
Paul is clearly trying to improve.
Satisfactory performance, consistent with the specifications of his job description, clearly trying to improve. Are these words and phrases which indicate incompetence to you, Ms. McMillan?
Objection, Your Honor. Argumentative.
Sustained. The jury is instructed to disregard that last comment.
You need to look at the evaluation instrument as an honest reflection of what the individual has done throughout the entire cycle, and then write it up and document it in a way that will reflect that behavior.
Honesty is the best policy and the way that you deal with other people. And if you're realistic in setting what your expectations are, in setting what your concerns are, in communicating those directly to the employees, very often you'll see improvement in performance.
What happened after the evaluation?
Well, Paul was Paul. He hadn't changed. So I compensated by taking on more of a workload and delegated between the rest of the team what work I could, but we just ended up working around Paul.
Did you talk to human resources?
No. I honestly felt it would just complicate the whole situation.
If you're working on your computer and it freezes up, and you've tried the standard things to fix it, what do you do? Very few managers would resist calling the MIS department and asking for somebody to come in and provide some technical assistance to resolve the problem.
Human resources can help detect the landmines before they explode, can actually give the supervisor a way to walk around them and to understand what's ahead and how it's going to be looked at in the context of the entire company. So you take the burden off the shoulders of the individual supervisor and instead make the problem a company problem.
Talking to human resources, you suddenly find out that every manager is struggling with some of these problems, and you start getting suggestions on how to deal with the problem, and you get an ally that will build a solution that will allow you to better address the problem.
You've got to be kidding me. It all came to a head when Paul handed in his monthly report, and the numbers were completely wrong. I mean, it was totally out of whack. So I sent an email to my boss, and I said we had to let Paul go. And then I threw in a comment that I shouldn't have.
Email is never ever gone. You have to assume that on a computer, all of the email messages and voicemail messages and other means of electronic communications are stored within the computer and can be retrieved at some point by a computer programmer.
There is a failure to recognize that this is not like a conversation in the back room. This is a form of communication where there's an electronic record made. So consequently, we get email that references something that is age-specific, somebody being over the age of 40, or something that is related to slowness attached to age, which taken in the context of 1,000 other messages doesn't seem that out of place. But in the litigation arena, with the ability to pull it out, blow it up, put it up in front of a jury, it has devastating impact.
Now, Ms. McMillan, is this the email that you prepared that day?
Yes?
And did you send this email to your supervisor?
It was confidential communication.
Oh, obviously not, Ms. McMillan. Now, would you please read the email message to the jury?
One of the members of my team, Paul Hayes, has become a real problem.
If the manager will simply communicate with the assumption that they're on the 6 o'clock news, to use all the power that's there electronically, but to be sensitive to the kind of language and statements that would be appropriate in the context of the workplace.
Paul?
Doctor's appointment. I left you a voicemail this morning.
Did your boss ever respond to the real issue?
The chronic lateness? Well, he warned me that I couldn't discipline Paul for being late unless I disciplined other employees who were also late. And then I realized that another one of the team members was late on occasion, and I never called him on it.
Why was that?
Well, I knew no matter what, I could always count on him to get the job done.
The fundamental claim in any employment law situation is that somehow the employer wasn't fair. And while that may get attached to a discrimination claim, a wrongful discharge claim, it still goes back to the issue of fairness. And how do you measure fairness?
What I try to tell managers and supervisors is that when they're making an employment decision, they should ask themselves, would I treat the person I think is my favorite person in the company exactly the same way? And also, when dealing with the person that the supervisor personally likes, would I do the same thing in dealing with the person I most dislike in the company? And if the answer to that is yes, then you know that you're going to be able to treat people fairly and alike. When you have a work environment in which people are treated fairly, where the standards are applied the same, you have better morale, you have more cooperation, more teamwork, and all of these help the work environment as well as avoiding these landmines and avoiding the problems that can result.
You know, the irony is that after I sent the email, the company went through a downsizing and I got a directive to eliminate one position. But since Paul had been with the company for 15 years, we decided rather than to fire him, we'd offer him another position in the company.
And the position you were offered, Mr. Hayes, was it comparable to the position that you held in Ms. McMillan's department?
Absolutely not. To begin with, it was in a different division, some 70 miles north.
So you did not consider this to be a viable alternative?
Viable? No, I mean, I'm supposed to uproot my children, take them away from their school, their friends, and everything they know, and bring them to a town they've never even seen? No.
Well, children are flexible, aren't they?
I couldn't do that to them, not after what they'd been through.
What do you mean?
My wife, their mother, passed away some 4 years ago, and it's been really tough for them to adjust.
When you're in a litigation environment, the reality of the workplace sometimes gets lost. And once there's the specter of unfairness, then evil motives can be attributed even when they don't really belong in that situation.
So you did not accept the position?
Of course not. That's exactly what they wanted me to do.
Objection. Move to strike.
Sounds like quite a performance.
Oh, it gets better. There's more. It was probably a week or two after Paul had left. I was having lunch with a colleague, and he started to ask me some questions about Paul.
I meant to ask you about this.
What?
I heard that you had to let some guy go. Is that right?
And I understand the two of you were having lunch. Now, did Ms. McMillan make any reference to Mr. Hayes' age?
No, not exactly.
Well, what do you mean when you say not exactly?
Well, I mean that she just said that the other people in the office, they grew up with computers. And Paul was
Was a what?
A techno dinosaur. A guy who grew up in the typewriter age.
I see, but you didn't take that to be a reference to his age.
No. I mean, I guess you could look at it like that, but
Thank you.
she just...
You've answered the question.
The moral of the story is that after an action is taken, you as a manager or supervisor must be very, very careful about discussing that case. Confidentiality is something that all employees expect and have a right to in terms of their personal matters.
And if you treat confidentially and you treat with respect the employment decisions and the employment and personal situations of the people who work under your direction, you're going to improve morale and you're going to create an environment where people will feel comfortable getting feedback and talking with you.
Mr. Hayes, just a few final questions. Would you please read this letter to the jury?
Certainly. Paul Hayes has served this company with enthusiasm, commitment, and unwavering loyalty. He's the kind of employee that every company values.
Now, Mr. Hayes, would you tell the jury who signed that letter?
It's signed by my former supervisor, Peter Shaw.
Well, apparently there was this guy who was Paul's first supervisor when Paul first came to the company way back when. And this guy, of course, knew nothing about what had gone on in my department, which is exactly why Paul asked him for a letter of reference.
Uncontrolled statements of reference represent a potential explosive problem in the workplace. People that are team leaders, are managers, are supervisors, speak as though they're speaking for the company. And accordingly, when they make statements that would either be positive or negative with regard to an individual, that can have a tremendous impact on the liability of the organization.
This is another example of the way that a communication can become spotlighted and given tremendous importance, even when it was intended in a very casual and friendly way and as something to help somebody find another job.
The proper procedure is to follow company policy and send the inquiry back to a central source within the organization for a proper response.
So, how did it all end?
We lost the case.
Where did that leave you?
The company was very supportive through the whole thing, but I just had to be realistic. There wasn't a future there for me anymore.
Well, that's why we're here, and I'm sure we can give you a fresh start.
You have just learned about 9 types of conduct that very often later explode in litigation. When you look at them and you see them exposed, it's not rocket science. It's something that is often very basic, but something that just misses awareness on the part of the manager. Remember that the simple action of documenting problems can often avoid litigation and actually improve employee performance. Consider the vital importance of employee training. Be sure employees complete the training they need. Recognize that an employee's work product is the best evidence of performance. When feasible, keep copies or a photograph of substandard work. When conducting evaluations, be timely, realistic, and consider the full period of the evaluation cycle. View human resources as your ally. Consult them early and use their expertise. When creating electronic messages, remember that every word could become public or potentially be retrieved in litigation. Treat employees consistently. When and if exceptions become necessary, make certain that they are well justified. When an employee leaves, be sure to respect his or her privacy, even in discussion with peers. Carefully control verbal and written references. When asked for a reference, check with human resources before you respond. And if you focus on these 9 landmines, learn what they are, you have a tremendous opportunity to reduce the likelihood that you go into litigation, but also see the potential for using these as tools to actually bring forward your ability to be an effective manager and to meet the challenges of the 21st century.